Good afternoon. Welcome to the House Judiciary Committee. It's January the 23rd. We have 9 bills in front of us this afternoon. We're going to start with Delegate Crosby and House Bill 5, then Delegate Attar and House Bill 21. Members of the committee have the lists in the order after that, and we'll just keep going. So with that, we'll hear first from Mr. Vice Chair from Economic Matters. Did you want to bring anybody else up with you? Okay, so I see Lisa Jordan, Debbie Feinstein, Joyce King. No? Okay, let's go ahead. Delegate Crosby, please.
Thank you, Mr. Chair. Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Brian Crosby here to present House Bill 5, entitled "Criminal Law and Indecent Exposure Within the Sight of a Minor." This bill has been brought forward, I think, 6 years now. It has passed out of the House the last 4. It has passed out of Senate JPR. The last 3 years and passed both chambers last year and was in the stack, I guess, before we had the hiccup at midnight. So that is why I think that we didn't conform to the Senate amendments. The bill is really in response to an incident that happened in my county where an individual exposed himself in front of young girls. The bill really just gets it to increase the penalty for those who commit indecent exposure with purient intent when a person committing the crime knows or should reasonably know that the minor is present. The minor has to be at least 2 years old and at least 4 years younger than the person who commits the crime. The whole purpose behind this is to trigger a clearance investigation from Office of Personnel Management at the federal level. What took place in this instance was the current penalties were levied at a maximum. It was 3 years imprisonment and $1,000 fine. Only the fine was levied at the maximum amount. And so that never triggered the investigation. The individual then was able to keep their TS clearance, move to a different state, and retain a pretty well-paying job. We simply asked to increase the penalties to 5 years imprisonment, not exceeding 5 years imprisonment, and $10,000 or both. And seeing how this body nearly passed this bill last year, and we've clearly passed it out of the House the last 4 years, I ask for a favorable vote.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with Maryland Coalition Against Sexual Assault. We're here in strong support, once again, of House Bill 5. The Maryland Coalition Against Sexual Assault is the coalition of all the rape crisis centers and sexual assault survivors across the state of Maryland. I am frequently in front of the Judiciary Committee and appreciate your attention. I know that these are difficult issues. So thank you, Vice Chair Crosby, for continuing to pursue this bill. It was a very painful moment when this bill was 2 bills down from the top last sine die and failed to pass. This committee has already reported favorably. Some things to think about. Indecent exposure requires intentional exposure. Case law requires it's intentional. This is not an accidental thing. The bill requires prurient intent. These are people who are exposing themselves to children for the purpose of sexual pleasure. They have to either know or reasonably should have known that a minor is present. So this is not accidental flashing. This is all intentional. And there's a specific provision allowing for a 4-year age gap to make sure that we're not talking about kind of kids versus kids. They're too young. They're kind of messing around. So it's really carefully crafted to address the gap in the law that Vice Chair Crosby has identified that allowed someone who was really a kind of a nascent sex offender to continue to have their security clearance. Just as a reminder, indecent exposure, although there are certainly scenarios you can imagine that are less serious, those can be PBJs or low sentences. There are also serious ones like the one described. So we urge a favorable report on House Bill 5.
Yes, thank you. And before I begin, Ms. Jordan, first of all, hearty congratulations to you on this being your 30th session with us. You've done a lot of good. My question is for Vice Chair Crosby or Ms. Jordan, whichever wants to handle it. The Public Defender's Office says that this is an unnecessary piece of legislation because of Criminal Law 1107. And I won't put the audience to sleep by reading the bit of the code, but it says, I will just read the first sentence. A person convicted of indecent exposure is guilty of a misdemeanor and subject to imprisonment not exceeding 3 years. And they also say that they are opposed to the sentencing enhancement. So my question is, number one, have you had a chance to see the testimony? And number two, what's your rebuttal to their concerns?
So I have seen their testimony against, it's been the same now, I think, for the last 6 years. And obviously, I understand that any kind of increase in penalty certainly triggers, a negative reaction from certain individuals and certain groups. And I get why some of that history exists, fully recognize it. I think that it is a necessary piece of legislation. And I disagree with them because they literally cite what the code reads, and the code is not enough to trigger that investigation for a clearance. And so that is what I'm trying to get at here. And so it is insufficient. What is currently in the law is insufficient to trigger that investigation to then go ahead and remove someone's security clearance.
Thank you, Mr. Vice Chair. Thank you, Ms. Jordan.
Thank you, Mr. Chair. Thank you both for testifying. I think I remember you testifying for a number of years. In fact, I think I've voted for this bill a number of years. So I'm assuming that we're going to hopefully pass it again. Here's my question. If you have a person, probably a man, who commits this offense, they are assessed $1,000 fine, but no prison term, or maybe maybe their prison term is suspended so that they're not triggered. It's not triggered, perhaps. They don't commit anything for the next 60 years of their life. They're a perfect citizen. They've kept their record clean. They've learned their lesson. They've did whatever the judge required them to do in terms of any kind of counseling or psychological assessment. Should they be denied the ability to continue their work? That's my question.
Well, I think that there's, first off, a higher bar anytime that you're in the DOD and you're dealing with classified material. Second is, just because you have your clearance removed does not mean you cannot petition to have it restored. And in fact, this is anecdotal evidence, but I know 3 or 4 individuals who have had their clearance reinstated after having hiccups with the law. So it's not, a forever, lock them up, throw away the key, and never give them any tools to do it again. It simply triggers an investigation that may or may not even lead to the removal of someone's clearance if this happens. But I do think that there should be a review conducted.
Just to be clear, what triggers the review?
It's the fine that would be,
The
certainly
fine
if
or the imprisonment?
either could, but if no imprisonment is levied, then it would be a $10,000 fine. So it doesn't necessarily have to even increase the penalty to 5 years. That was an amendment that was put on actually by the House 3 years ago. But it is certainly, if you hit the $10,000 cap, if you hit the $10,000 fine and that is levied, which the judge doesn't have to do that, there's still discretion, then that would trigger the investigation or 1 year imprisonment.
Delegate Carden with a question.
Mr. Chairman, thank you. Could we, if we allowed for a $10,000 fine and it can be levied and then suspended pending successful completion of a probation, would that then trigger so that you could do it without necessarily requiring the person to pay all $10,000? Do you know? You may not. This may be a little bit too in the weeds.
I don't know that answer.
Okay.
I can reach out to OPM and find out.
All right. Thanks.
I guess the other question is, this is legislation is seeking to distinguish between an indecent exposure and indecent exposure done deliberately in front of a child.
Correct.
Okay. That's the sort of bigger picture here, apart from the DOD or OPM or whatever.
Right.
Okay.
I'm just trying to trigger the investigation on that very specific narrow crime.
All right. Are there further questions? Seeing none, thank you both very much. We'll hear now from the Office of the Public Defender. Because I don't see Debbie Feinstein and I don't see Joyce King. Vanita Taylor? Vanita Taylor from the Office of the Public Defender? Okay, that concludes the testimony then for House Bill 5. We will move on. Delegate Attar, come on up for House Bill 21. You can bring up whoever you'd like to bring up. And there are many.
Thank you, Mr. Chair.
Bringing up Ms. Murphy, Mr. Palma. Right, all right. Okay. Who else are you bringing up?
Just this.
Okay, go ahead.
Thank you, Mr. Chair, Madam Vice Chair, and honorable members of this committee. For the record, I'm Dahlia Attar here before you with House Bill 21, warrantless arrest for straw purchases. I brought this bill originally 3 years ago. This committee, it was in a little bit of a different form. It actually asked to change straw purchases from a misdemeanor to a felony. And this committee strengthened the bill and amended it and changed it to include it in the lists of warrantless arrest exceptions. I took that guidance and the following year brought this bill before you. This committee passed the bill last session. It passed the House of Delegates. It stalled in the Senate. I'm hoping this is the last time I'll be in front of you with this bill. And I do have some of my colleagues here to give some me toos and some very quickly, but I do know we have some new members of this committee. So I just want to say that this bill is intended to go after those individuals who purchase a gun legally and they take that gun and then they give it to or sell it to individuals who are prohibited from having it, whether it's a child or someone who is a convicted felon. So the goal is to make it easier on law enforcement to go after these individuals, many times who are coming from out of state and selling them to individuals who are prohibited. From my experience, 8 years as a prosecutor in the city, I've seen it happen many times, but because it's a misdemeanor and because it's not a warrantless arrest exception, it makes it very difficult for officers to then go find the person who came from out of state or from wherever and go after them and arrest them for selling this gun illegally. So with that, I ask once again for a favorable report, and I'll turn to the panel for quick me toos.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Erin Murphy. I'm here on behalf of the Baltimore City Police Department. I do not need to explain to this committee the effect of the amount of firearms on our streets are having on our communities. My commissioner said it very well on the scene of a quadruple shooting on Friday night. Disputes are now turning deadly due to the accessibility of firearms. I came down to testify on behalf of this bill last year. It was my second day on the job. I came down because it was very important to the seriousness of this conduct needs to be punished. And that is why I'm back here again today. And we are requesting a favorable report on House Bill 21. Thank you.
Good afternoon, Chair Clippinger and Vice Chair Bartlett, members of the committee. My name is Max Palma, and I'm a major with the Baltimore City Sheriff's Office. I'm here to testify in support of House Bill 21 on behalf of my office. And there should be some written testimony already submitted to you and in file. I'd like to not speak on that, but add two main points. One is that the Baltimore City Sheriff's Office serves more warrants than all the other sheriff's offices in the state of Maryland. And serving a warrant is an important part of our work and also our constitutional duties. And obtaining and serving warrants is a time-consuming process. And so the General Assembly has already made provision and created exceptions allowing us warrantless arrest. House Bill 21 will add the language of the straw purchasing into it, which is very important. The second point and final point I'd like to make is that the Baltimore City Sheriff's Office does collaborate and participate in the federal and state task forces in focusing in getting illegal firearms off the streets. And so most of these firearms, most often these firearms are connected to trafficking or these firearms are being seen as a crime, what we call a crime gun, so associated with violent crimes. In my experience, when we have probable cause and we have a tip and there's probable cause that bad actors are in a process of selling illegal firearms. We need to move quickly to get to them, and most importantly, to get the firearms, to seize them so it doesn't disappear. To get to the warrant, it would, as I stated before, it would create the time process, which most likely when we get to the bad actors, the firearm is already gone and is into our streets. So House Bill 21 will set the urgency, and we'll put the real measure into the effort of stemming the flow of firearms into our community. So I'll move to kindly ask you to favor the report.
Thank you. Go ahead.
Thank you. My name is Lauren Lipscomb. I'm here on behalf of the Office of the State's Attorney for Baltimore City, State's Attorney Ivan Bates specifically, as well as on behalf of the Maryland State's Attorneys Association. And we are joining the panel here in asking for a favorable report for this valuable piece of legislation. We do thank Mr. Chair, Madam Vice Chair, as well as Delegate Attar for bringing forward this very important piece of legislation that will help in our fight in Baltimore City to combat violent gun offenses, as I think everyone is well aware, is something that continues to plague our community. We appreciate this committee's favorable vote over the last 3 years, and we certainly look forward to perhaps another favorable vote this year. Thank you so much.
Other questions for the panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. In reference to the warrantless arrest in Baltimore City, how does that play along with the consent decree?
I don't know the answer to that.
As long as it's constitutional policing, we are not in violation of the consent decree. So if it was passed into law, right now there's exigent circumstances, obviously for certain warrant exceptions. And I know that before we've gotten questions about the sanctity of the warrant, the warrant process. And I can't think of more exigent circumstances than firearms in the hands of people that should not have it.
Right, but in order to execute this warrantless arrest, you're supposed to be able to articulate the fact that you at least saw a portion of a handgun. Is that correct? Under the consent decree?
I'll touch on that. So most likely we would have it's either an ongoing investigation, or we would have a tip from the citizens, concerning citizens saying that illegal firearms are at this location or getting sold by these individuals, questionable actors. So that for us, if we know already the area, or we're familiar with the area, we quickly verify the information, will give us a probable cause. That's what we're asking. We're asking that will give us a probable cause to action immediately. And so, and the sheriff's office is not under consent decree. So we would immediately action that tip in the spirit of taking the guns off the streets. So our goal is not necessarily the bad actors. That's going to be part of the investigation, but it's to get the guns off the street.
Yeah, so you're saying that you'll be able to skirt the consent decree because you're not a police officer, but you're a sheriff?
So we're police officers and sheriffs. It's one of the same. There is a misconception of that. The sheriff's office is not under consent decree. It only touches the Baltimore City Police. That doesn't mean that we're not in this fight together. In this table, we're all fighting together for the same, for the common goal of getting firearms off the street. The point I'm making is that the warrantless arrest will give us the ability to immediately act on a probable cause situation where illegal guns are sold, and then we will take the guns off the street so they don't disappear.
A probable cause that's not witnessed by law enforcement, is that correct?
Well, probable cause is, so let's say for instance that we have a tip from a citizen saying this store over here is selling guns and it's questionable the way they're selling guns. Okay, so we will go and look at what the issue is, or maybe a citizen has guns and sells them or transfers them to other individuals without the proper protocol. That's the probable cause for us to look into it.
Thank you.
If I can add, I just want to point out, you still need probable cause. I think I didn't understand your question when you first asked it, then with your follow-up, I do. You still need probable cause. So this doesn't affect the consent decree. It's still needed.
Thank you.
Anyone else? All right, seeing none, we thank you very much.
Thank you.
So that concludes the testimony of those people in favor. We're now going to those people who are opposed. There are two who are virtual. Debbie Levy and Katie Novotny are virtual, and we're going to work on that. Mr. Pennock is here and going to come on up. And while they're working on the virtual side, we can hear. Okay, so they're in the room on the. Okay, that's fine. We'll start with Mr. Pennock, then we'll go to Ms. Levy and Ms. Novotny after that. I see Ms. Novotny on the screen. Mr. Pennock, please, for 2 minutes.
Thank you, Mr. Chair. I'm here in opposition to this bill as president of Maryland Shall Issue. Now, let's be clear, no one here in this room, nor I, are in favor of straw purchases. It's severely punished under Maryland law. It is severely punished under federal law. It is a federal felony. And that is as it should be. What I am here is to object to the diminution and the dilution of the warrant requirement for making arrests. This body of all bodies should know, after the experience with the Baltimore Gun Trace Task Force, that the warrant requirement, which interposes a judicial officer between the arresting officer and the suspect, is an important requirement. It's constitutionally required. There are minor exceptions for it. This blows a big hole into those minor exceptions. I'm not going to sugarcoat this. You need a warrant requirement here because otherwise police are prone to abuse their powers. You should not be kidding yourselves about that. You have only to look at the consent decree entered against the Baltimore Police Department by the U.S. Department of Justice, where I used to work, and to see the whole rampage of unconstitutional actions taken by Baltimore police. There is no trust of the police department in the city of Baltimore. None. And every time you dilute the warrant requirement, you add to the level of distrust. The easy thing about here, if they suspect a dealer is engaging in straw purchases, get a warrant. It's not hard. You heard testimony today that they have reason to suspect. Well, present those reasons to a judicial officer and get a warrant. It's not hard. And that's the bottom line. Warrants are there for a reason. I'll be happy to answer any questions.
Have to do it this way. Ms. Levy? Debbie Levy? Okay. There she is. All right. Hear from you for, I know. We welcome you in. We ring a bell. These are the new things, I guess. Ms. Levy, are you there? Can you hear me?
I can. Can you hear me?
Yes, we can. And you can go ahead for 2 minutes, please.
Okay, thank you very much. This is Debbie Levy with the Office of the Public Defender. I'm the Director of Special Litigation, and I'm here to urge an unfavorable report for House Bill 21 because the bill serves to erode important protections that are required by the Constitution, and it does not rationally further any public safety concern. The Constitution protects an individual's right to be free from searches and seizures, and as part of that protection, the Constitution and the Maryland Declaration of Rights require a warrant for a person's arrest, except for a certain set of exceptions, namely misdemeanors committed in the presence of an officer and felonies. House Bill 21 aims to add this transactional crime to a small list of misdemeanors that are exempt from the important step of requiring a warrant. But simply put, there is no increase in public safety that would result from removing the requirement that a police officer get a warrant and engage in judicial oversight before arresting someone. Warrants are readily available, and the majority of misdemeanor crimes in our state require that step. Listening to the debates and the justifications put forth today and in prior years, this bill seems to simply be a reactive and subject matter based rather than proactive. What is missing is any evidence at all that this bill will make our community safer. And in fact, removing the important check of the requiring a warrant has the potential to actually make everybody less safe. If the legislature is seeking to be proactive and subject matter based to increase safety, research shows that communities are made more safe when we invest in them in a proactive way, providing services and support, not in this reactive way that erodes important foundational requirements that serve as the basis of our society. We urge the legislature to invest in our communities and continue building trust rather than further eroding our citizens' protections. We urge an unfavorable report for House Bill 21. Requiring a warrant and some level of investigation is a sound requirement that our legislature ought not to disturb. And if I have any time left, I would say all the examples put forward by the prior speakers in favor are investigations that could get a telephonic warrant from a car, keeping judicial oversight in place. There was no data, it was all anecdotal. There's no reason for this bill to go forward. Thank you very much.
All right, Ms. Novotny, please, for 2 minutes.
Hi, good afternoon. This is Katie Novotny, and I oppose this bill. It's been clearly stated by the previous two witnesses on all the legal reasons why. And so I just want to briefly add that, it was mentioned, the time, we can't waste time getting these warrants by the proponents of the bill. And my rebuttal to that is people's Fourth Amendment rights are worthy of spending that time. As she mentioned, you can get a telephonic warrant. This can be done very quickly. So we need to protect people's rights, especially in these areas where the police have abused its citizens in the past. I request an unfavorable report. Thank you.
We have questions now. We'll start with Delegate Grammer with questions, please.
Thank you, Mr. Chair. I have a brief question for Ms. Levy. Can you tell us what the risks are? Because you help people who are defendants in these cases. Can you tell us what some of the risks are if we were to take away the warrant requirement in these particular cases?
Well, I think the number one risk is that you are putting officers in positions that increase danger. Certainly, everybody would agree that already an arrest with a warrant is a dangerous encounter between law enforcement and the public. When you take away the judicial oversight, you are not adding for that period of time, that 1 second pause, wait time. Am I making the right decision? Am I doing the right thing? You are respecting the Constitution. And from a broader standpoint, I hail from Baltimore, a jurisdiction, as many people have said, under consent decree with a police department that engages in unconstitutional policing. And so taking the constitutional protection away ought to be something that should be reserved for the most egregious, most emergency situations. This is not one of them. An officer loses the ability to second guess their judgment, to ask somebody else to second guess their judgment, could be hot in the middle of an activity with an individual, and just lacking in any oversight to make sure. The example that the sheriff gave, look, if you're investigating a store and you think that they're selling illegal guns, go make your own observations and go ask a judge if you've formulated probable cause. But the reason that second step is in there is not just to protect the Constitution and protect the trust, but to lower also the temperature in a transaction. This is a transaction crime.
Thank you.
No, I never even touched it.
Don't you have any further questions?
Nope.
Hey, thank you, Mr. Chair. This is a question for Mr. Pennack. I have a recollection that in a prior year, when you testified on this bill, you had suggested that your preferred approach to the problem would have been to simply felonize the offense. I don't know if that rings a bell, but I'm curious if that was, I believe, how the sponsor introduced the bill years ago. And it eventually morphed into the form you see here. But if you could comment on whether that addresses your concern, I do think you pointed in that direction in a prior year.
That's correct. I have, and a felony need not get a warrant if you have probable cause. And that's established law in Maryland and elsewhere. So that is a better approach, frankly. That is the approach taken by federal statutes. They make it a felony. So if you really don't want to have judicial intervention here, and you really think somebody can be arrested without judicial intervention, make it a felony. It's a 15-year felony under federal law, as recently passed by Congress, Section 932 of Title 18. So yes, that's one alternative you can do. It's already a felony. So why are you diluting the common law and the established warrant requirements when you don't have to?
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Ms. Levy, roughly how long do you think it'll take to get a telephonic warrant?
An officer can get, thank you for your question, Delegate. An officer can get a warrant from their car. There are judges on duty 24/7 to get a warrant.
10 minutes, 5 minutes?
I think that, I mean, I haven't gone through it myself, but I understand that they have phones in their car, they have computers in their car, judges are on duty all night, they can get electronic signatures, so it should be in an instant.
Thank you very much.
Thank you, Chairman, and it's good to be back with my fellow colleagues. This question is for Ms. Levy. Does this bill could it potentially have an adverse negative impact upon the minority populations disproportionately?
I mean, I think that what startles me, it could have a negative impact on everybody. Our minority populations, oftentimes the subject of unpoliced policing. Oh, yes, 100%. I think that's a good question, and we all know essentially the answer to that. The other thing that's problematic is that it's asking for arrests for uncorroborated tips, and that's just not good law enforcement, right? Both of the examples that the prior speakers gave said you could just get a tip that somebody's dealing guns and then or engaging in a straw purchase, you could immediately arrest them. Nobody wants that. Nobody wants that extra step without further investigation before anyone is arrested. So I think certainly persons of color, minority populations would be subject to arbitrary policing in that regard, but also generally the entire population should be wary of a lack of further investigation before imposing in the most strict way against somebody's liberty. It's a bedrock principle.
Further questions? Seeing none, thank you all very much. That concludes the testimony on House Bill 21. We're going to go now to Delegate Grammer and House Bill 6. Debbie Levy can just stay right there because she's testifying in favor of Delegate Grammer's bill. They are the two people to testify. So we'll hear first from Delegate Grammer. Go ahead.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 6. House Bill 6 eliminates the use of law enforcement quotas. When former Baltimore City police officer Michael Wood was asked what his suggestions were for improving police culture, he recommended that we think about what our goals are. He lamented that the metric that was given by leadership was arrests and spoke about how he would patrol his detail looking to satisfy his quota. He couldn't do that in the rich part of his assigned precinct that was predominantly white, and he explicitly stated that he would drive to the Black community in his patrol area to arrest people for jaywalking or littering. Proper policing is driven by community feedback. In many places in our state, we implement the opposite, top-down policing implemented through quotas. Behind closed doors, officers are squeezed to produce higher numbers. Law enforcement quotas destroy community trust and incentivize bad policing. Formal quotas are actually prohibited by state law currently. However, they are commonplace in our state due to the loose language of our current statute, as demonstrated us by the formal quota system shared with us by state police officers. This is in front of you, by the way. After last year's bill hearing, more examples surfaced. The Southern Maryland Barracks shared their matrix. A stop gets an officer 1 point. A juvenile arrest gets them 20 points. Reports from the offices of the state police and Department of Natural Resources showed that those penalized for not making numbers had their cars taken. Reports from officers of the state, it gets worse. Local sheriff's offices report having quota systems for investigations and even the issuance of warrants. Literally, the state has jurisdictions where doors are kicked down to satisfy a quota. Where are the incentives? If you're concerned about over-policing, we should reconsider the stage we have set. I have submitted to the committee an amendment aimed at addressing the concerns of some committee members that, given time, I'd like to discuss. Be happy to take questions, and I'd ask for a favorable report on House Bill 6.
Debbie Levy, please, for 2 minutes.
Thank you. My name is Debbie Levy, Director of Special Litigation with the Maryland Office of the Public Defender, and we're here to urge a favorable report for House Bill 6 because police quotas, whether formal or informal, introduce perverse incentives into an already stressed aspect of our local communities. Put simply, they distort any valid public safety concern that community groups say are served by policing. In his law review article titled Police Quotas, Professor Sean Osei-Owusu from the University of Pennsylvania's Carey Law School explains that quota-based policing is the one single area where there's widespread agreement that change is necessary. More specifically, Professor Osei-Owusu explains, this is the one area in policing where liberals, libertarians, conservatives, police officers, police unions, and racial minorities have shared the same viewpoint and criticized quotas. These vastly different constituents have argued that quotas distort police discretion and produce unnecessary police-civilian interactions. Because of this common viewpoint, police unions, criminal defendants, civil rights plaintiffs, and aggrieved police officers have all supported statutes aimed at preventing quotas. And this is for good reason. As the professor documents, law enforcement quotas pose significant issues for 3 separate groups: marginalized communities who are almost always the target of an officer's need to fulfill their quota, police officers who are forced to comply and not empowered to use their own discretion during their shifts, and the public that is deprived of a more effective use of law enforcement resources based on quotas. While Maryland law already forbids some quotas, this bill takes this option one step further, and in doing so aims to change the culture and the mindset that influences formal quotas, like the citation quota in Ferguson, Mississippi, that led to the death of Michael Brown, and the informal quota, like the one announced in a letter in Baltimore that led to the death of Freddie Gray. Quotas affect the mindset of the police and the ways in which communities and criminal defendants perceive them, and there is simply no place for them in Maryland's law. As a result, we urge a favorable report for House Bill 6. Thank you.
Thank you, Chair, and thank you, Delegate, for bringing this bill forward. What exactly are you referencing when you talk about quotas for investigations?
Yeah, so there was a big discussion about this bill after we had our hearing last year. A lot of officers from different agencies from around the state called into my office, talked to me, as well as other members of the committee. I got a call from a gentleman who worked for a sheriff's office on the Eastern Shore. And they said, you're not going to believe this, but we actually have numbers as far as investigations we need to culminate. We have to issue a certain amount of warrants per month due to our local quota. And he would say, I'd have an investigation. It's a legitimate investigation. I think spending more time on it would allow me to, make it a more effective case, but they're really getting squeezed to push it out the door. So literally they're issuing warrants, they're going out and arresting people. They're kicking down doors to satisfy kind of the local demands of local leadership.
So they're tracking numbers on the investigations.
Oh, yeah.
And also on the warrants.
Oh, yeah.
All right. Thank you.
Delegate Munoz.
Thank you, Mr. Chair. Delegate, what can you tell us about this amendment you referred to?
Yeah. So I've had a discussion. I've talked to a lot of people. As you can see, there are quite a few people from the committee on the bill, and I appreciate their support. So one of the concerns, what we're talking about here is an agency who are trying to monitor and evaluate their officers to ensure that they're doing their job. On the flip side, you have frankly, most people who don't want to have a formal quota system, they don't want to have their law enforcement driven by numbers. So the concerns of a few members were that, how do you allow an agency to discipline their officers to make sure, frankly, they're doing their job without getting into the statutory weeds of, considering the number as a holistic metric. So what we did is we took a shot, and I'll work with bill drafting. I'll read it briefly. The prohibition on establishing quotas does not preclude the use of quantitative data for law enforcement activities as management tools or evaluating that a particular law enforcement officer or group of law enforcement officers does not violate an applicable legal obligation. So in other words, they're saying as a law enforcement officer, you're legally obligated to do your job as long as you're not considering those numbers as a policy. You could look at that as a fact finding. Look, this officer's frankly not making an attempt to do his job here. And I'm not a stickler on the language, but I wanted to take an attempt to resolve it. Thank you.
Yeah, that's really interesting because my question would be if you have an officer who's sent out on duty and they sit in a like they're doing traffic and they just sit in a parking lot all day. No offense to officers like on Netflix or something, like doing literally nothing.
Yeah.
How are their superiors I guess able to quantify or discipline them or move them from one unit to another?
That is the concern. That's a concern by a couple members of the committee. And I think the question is, how do you legally separate it? Because frequently they'll have evidence, they'll have GPS monitoring, they'll have someone corroborate that. And then they want to say like, look, legally, this person is doing nothing. They're not issuing citations. They're not patrolling. They're not doing any arrests.
So would that fall under quotas? Like, how would they count that then?
Well, that's the question. How do we deal with that issue without getting into the policy? And that's what we're trying to do with that amendment.
Thank you.
Thank you.
Thank you, Mr. Chair. Okay, so this is really good information that you provided us. It's always helpful to see it in a hard copy. Some of these emails, as you well know, are disturbing, frankly.
It gets worse.
I'm sure it does. I have no doubt. So along the lines of Delegate Muni's question about how can we make sure people aren't just, I've personally seen someone back in the day playing Xbox in a parking lot. I just sat there for a while and I was like, that is a sweet gig. This is before I had a job. God bless them for what they do. But that is concerning. So what if we made it like a secondary thing? So what if we said you can introduce this as evidence in somebody's disciplinary action, but that can't be your first piece? Do you know what I mean? Like they have to come in, essentially they have to have probable cause to look at it, to analyze it.
Very interesting question. So as this issue goes, here's the story. Delegate Mike Smeagol tried to get this fixed around 2006. He had a pretty strong language in his bill, and it was amended in this committee, and they added the language sole or primary criterion. So what does that mean?
Right.
It's pretty loose.
Yeah.
And I'll show you what you get when you have that language. You get a formal quota system.
Right.
This is in direct violation of the law.
Right.
So I understand the concern fully.
Yeah.
I'm trying to do that with this amendment. I'm not a stickler on the language. So if you or someone else wants to help out with that, I'm more than willing to listen.
All right. Thanks very much. Thanks for your work on this.
Would this legislation stop a local sheriff's office from posting a list of open warrants?
I don't see that it would.
But it suggests or requests enforcement actions to direct an officer to act for the purpose of increasing the number of investigations conducted, warrants served, or executed. So posting a list of open warrants would be problematic here.
Is that with the intent of increasing?
I'm asking you the question.
I don't
get
believe
to
it
ask me
is.
the question. What?
Yeah, well, that's the minutia of what we're dealing with here. And if you talk to these officers, they'll tell you straight up, like, well, we don't have a quota that I can show you somewhere, but they kind of insinuate through this or that, and we're really getting squeezed. My answer would be no, because if you're posting the warrants, they're not intending to increase the issuance of warrants. That's just a natural function of the department.
The warrants executed, would a warrant task force have to be eliminated under this legislation?
I don't see that it would.
But it says that we're suggesting or requesting enforcement actions that would result in more warrants being executed. So would it not eliminate those warrant task force?
I would disagree that it would absolve a task force aimed at a legitimate function of criminal justice that is not intended to deliver warrants with a policy of driving up the numbers. I would have to disagree with you there.
I'm sorry, I don't understand what you just said.
Wait, I think, my concern is the leadership guidance that's been given to people. And it's about driving up the numbers. And I would disagree that a task force that's tasked with issuing warrants.
But this is executing warrants.
Right.
Which is, okay. The distinction is executing warrants, I think, as opposed to serving.
Understood.
Or I think, well, no, it's actually serving and executing the warrants, but okay. I'll stop there. Are there further questions? Seeing none, thank you very much. That
Thank you.
concludes the testimony on House Bill 6. We're going to go now to House Bill 128. And that's Delegate Rosenberg. Come on up. And it's just you, which is just fine. We'll hear about 128 now. Go ahead.
Thank you, Mr. Chairman and members of the Judiciary Committee. Whenever a witness in the judiciary is intimidated or there's an intent to harm that witness, it is a criminal act under existing state law. What House Bill 128 would do is, by copying, in effect, the existing provisions of law, is provide for the same criminal penalty in the same circumstances or the same acts that seek to intimidate or harm an individual because of that individual's testimony sitting here, testifying before a committee of this legislature. This is much narrower. This bill is much narrower than the legislation that I offered 2 years ago. It is modeled on the existing law. It is prompted by a conversation that Delegate Kipke and I had at an HGO hearing last year, where he recounted for me, and there is a letter forthcoming to the committee. It wasn't submitted to us in time, but it'll be sent to you individually, recounting the intimidation that a independent pharmacist got from their benefit manager after the pharmacist testified upstairs before HGO. I've also spoken today with another pharmacist who asserted that he had been coincidentally, in quotes, presented with an audit by his benefits manager soon after he had testified before us. There are amendments that I will be offering that would add the requirement of recklessness on the part of the alleged perpetrator. That's prompted by a recent Supreme Court decision in Quarterman, which is the subject of legislation that I will be presenting to the committee later this session in another, dealing with that standard in another context of the recklessness standard. So what we're dealing with here is an individual who causes harm to a witness or seeks to cause harm to a witness before this body and would be treated, the crime is modeled upon the language for harm perpetrated upon an individual testifying or asked to testify before a judicial body. So I would seek a favorable report from the committee, and thank you.
Vice Chair. Thank you, Mr. Chair. And thank you, Delegate, for bringing the bill. I have a couple of questions because it says legislative proceeding and in the bill, and it says that includes a meeting of a legislative body regardless of whether the General Assembly is in session or is not in session. How could the intimidation actually occur on the floor of the General Assembly? In theory, yes, right?
Oh, you mean based upon something that someone had said there someone then sought either before or after the fact to prevent them from speaking on the floor.
Yes.
I would think that I would want that to be covered.
Okay.
Yes.
And so how does that square with the immunity that one has when they're on the floor and what they say on the floor? Can you just square that up for me?
Sure. We are protected by the speech and debate clause, but an individual who is thwarting us from exercising our authority right to speak certainly does not have that same protection.
I guess
If
what
you
I'm,
were to extend the bill to apply to that,
yeah, I'm speaking of the individual on the floor. If it were a legislator on the floor and that legislator actually is found to be intimidating a witness, how does that square? That's where I was getting at.
oh, okay. You'd have to overcome, and I'm sure there's case law, which I'm not familiar with. You would have to overcome the protection that the member has under the speech and debate clause for things said during debate on the floor or in a committee room.
Would you be interested in a friendly amendment to make sure we overcome that area? Because that's, to me, I think we need to square the two.
My thought would be, there should be a request to the Attorney General about the appropriateness, how to do that if it can be done appropriately, given the protection for the members.
Okay, right.
Hello,
Hi.
Delegate. So I have a question. Harm is not defined. It's not limited to physical harm. Would, for instance, a disciplinary action by an employer be covered if, for instance, an employee violated company policy and testified in a way that was prohibited by an employer and was then disciplined because of that?
Well, you do have the case law, and there have been, it's my recollection, prosecutions brought under the existing law dealing with the interference with a judicial proceeding. So you would have that precedent. And then I don't know whether our Supreme Court would apply the plain meaning, what's the dictionary definition of harm, but there should be case law speaking to that.
But in the judicial context, there's a subpoena, so they're ordered to be there by the court, and they are also under oath. Whereas testimony here is voluntary and covers a wide variety of issues, both factual and emotional. So it may be helpful to be a little more specific about what.
I certainly would be fine with a friendly amendment. Yes,
Thank you.
and would ask if it's possible to work with you.
Of course.
Thank you, Mr. Chairman, and thank you, Delegate, for taking the time this morning to speak with me. I've noticed that the violation of this would be subject to imprisonment not to exceed 10 years or a fine not to exceed 5,000. Does that mirror the judicial law or is it different?
I'm looking for it. I'm sure it's the same. I have every reason to believe it's the same. And if it's not, it should be.
Okay, thank you very much.
Yes, Delegate Rosenberg, it's good to see you as always. And I see, and I think it's a good bill, and I see this testimony and support from Epic Pharmacy. But I understand that there is a Maryland Pharmacological Association. And did they weigh in on this bill? Because you said you were doing it on behalf of pharmacists, which are rather commendable. But if they didn't weigh in, does that suggest this is not that big of a problem?
I don't recall saying that this was being done on their behalf.
Oh, I know, but you said you gave an example of the PBM manager. So I was just wondering, because you used them as an example, if the Pharmacy Association for the state weighed in.
I did not ask them to weigh in. I was looking for the individual. The letter that you have is the instance that Delegate Kipke discussed with me last year. So that's why we have that letter.
Okay, thank you for clarifying. Good bill.
Thank you.
Thank you, Mr. Chair. Hello, Professor. Good to see you. My question is, I think you've been here longer than anyone else in this room. And based on your personal experience and what you've seen, what do you think the short and long-term effects are of ordinary citizens in the state of Maryland being intimidated through financial, career-related retaliations on the actual legislation that comes through here and moves out of here?
They won't testify. And that diminishes our process.
And so do you think the more powerful entities will get what they want done and these groups will lose their voice?
Well, whoever they're testifying for, because there could be instances, I appreciate your example, but there could be instances when a, say a left-wing group, is a member of a left-wing group is guilty of this offense. So against big business.
Mm-hmm.
So it's neutral in that sense.
Mm-hmm.
It would apply to any witness, the intimidation of any witness
Mm-hmm.
who seeks to testify or has testified before this body. As I said at the outset, just as we already treat a witness in a co-equal branch,
Mm-hmm.
in the judicial branch.
Okay, thank you very much.
Okay, I'm gonna go ahead. So the legislation says that you have to have the intent to influence a witness to offer false testimony, but it doesn't actually require the testimony to have been offered and demonstrate that it was false. And that you're inducing a witness to be absent, but it doesn't necessarily mean that the person had to be absent. In other words, there's not an action that has to be taken here, as I read the legislation. Am I reading that right? And is that deliberate? I'm not saying that's a good or a bad thing. I noticed that. And
It's
wanted
the
to throw it out there.
precedent that's how the existing language for the judiciary reads, or all.
Sure.
So that's the committee's discretion if you want to move forward there.
Any further questions? Seeing none, thank you very much.
Thank you.
That concludes the testimony on House Bill 128. Moving right along, Delegate Frazier Hidalgo, who is right there. This is House Bill 8. And do you have witnesses? You have a virtual witness, Jason Spiegel. And Marcus, there he is. All right, we will get Mr. Spiegel on. He's in. Okay, great. Delegate, go right ahead.
I know it. Same thing happens in mine too. That's why I don't want to press it. That's why I asked. All right. Mr. Chair, am I ready? Okay. Thank you, Mr. Chair, Vice Chair, members of the committee, so much for having us here on House Bill 8. As you can see, it is a very low number because the House and this particular committee saw in its infinite wisdom to pass this bill last year. So I ask that you pass this bill again this year. It'll go over the Senate's in the same posture it was last year. And this bill is simply designed to maximize the pool of applicants for police departments. As you are aware, police departments around the state, particularly in my county, which is why I have my wonderful chief here, is really short on police officers. And the chief can talk to you more about percentages and numbers. But look, we all know at the end of the day, if you want the best sports team on the field, the larger pool of applicants you have, the better. So this just opens up those applicants. And in particularly, this committee passed a couple of years ago that opened up the applicants to honorably discharge members of the armed services. And this increases that also to the National Guard, the Army National Guard, the Air Force National Guard. And that is really the big piece of the bill. It also waives the part about citizenship, which is already what you passed. This just waives the part about having to have applied for citizenship. And I can talk in detail about that. But again, this is the same exact bill you passed last year. and it flew out of the House. So if there aren't any questions, or I don't know, Mr. Chair, if you want to have the, okay.
Good afternoon, members of the Judiciary Committee. Thank you for considering my testimony regarding this legislation. I am Chief Marcus Jones of the Montgomery County Police Department, and I am testifying in favor of this bill that expands the Freedom to Serve Act, that as Delegate Fraser Hidalgo stated in regards to you all passing this bill in the House last year. Law enforcement agencies can always adopt stricter hiring standards, but need to expand the standards set by the Training Commission, adding the provision of needing to be in the process of becoming a U.S. citizen excluded a percentage of non-citizens from applying. And this bill seeks to rectify that. Recruiting high-quality police candidates has been made more difficult in recent years. There's well-documented data to support that there are fewer individuals in today's workforce, and this trend will not change in the coming years. Law enforcement agencies continue to experience challenges recruiting well-qualified individuals willing to serve their community as law enforcement officers. And we should trust those who protect us and trust those in leadership to choose the best candidates to serve in our communities, and this provision will boost the servant ranks. So I again would hope and wish that this committee would pass this bill once again as we move forward to adding more public safety servants in our communities all across the state of Maryland.
Mr. Spiegel, if you'd like to go ahead now for 2 minutes, please.
Thank you, Mr. Chairman. For the record, Jason Spiegel, President of the Maryland Military Coalition. We strongly support HB 0008, the Freedom to Serve Act. The bill would expand the pool of potential law enforcement officers by including honorably discharged veterans and members of the National Guard and Reserve, whether or not they have a pending citizenship application. Veterans and reserve component personnel have already demonstrated their willingness to serve their country and community. They have undergone a rigorous U.S. government background investigation and been trained in the safe use of weapons and rules of engagement. Moreover, everybody who has ever served, regardless of their specialty or branch of service, has performed law enforcement functions by performing guard duty, credentials checks, and similar activities. They have been trained in civil disturbance and crowd control. Critically, Maryland needs law enforcement officers who speak foreign languages and possess cultural sensitivity who can interact with non-English speaking immigrant populations. Veterans who are themselves immigrants will bring these vital skills and experience, including cultural competency, to their law enforcement activities. We strongly support the inclusion of the Guard and Reserve in the bill. Members of the Guard and Reserve live in the communities where they would serve as law enforcement officers. Moreover, all National Guard personnel, regardless of their actual military specialty, are trained to support law enforcement and perform civil disturbance response. Many Maryland National Guard personnel were on duty at the Capitol after the January 16th incidents and were on duty in Baltimore after the death of Freddie Gray. I also want to note that my hometown, the city of Gaithersburg, America's most diverse city, has endorsed this legislation. We urge a favorable report on the bill. Thank you.
Questions for the panel, please? All right, seeing none, that concludes the testimony for House Bill number, did I miss one? I'm sorry. Yes, Delegate Tomlinson, go ahead.
I was just looking at the amendment from the Chiefs of Police Association. Any thoughts on that, or
the amendment?
Or sorry, what they're proposing?
What exactly are they proposing?
They were asking to, I think, add back in that that the individual has applied to obtain U.S. citizenship. I think that's what they're asking.
Yeah, so the reason we wrote it the way we did was because we're opposed to that particular provision. It's I can go into an exceptional amount of detail if you'd like, but the reason that it was passed last year was because that was hampering some of the applicants. And again, these are permanent legal residents that have been honorably discharged from the military. So we didn't really see the need to have that. It kind of shrinks the pool a bit. Thank you.
Gotcha. All right, thanks.
Seeing no other questions, we thank you all very much. And that concludes the panel for House Bill 8. Thank you, Delegate Pasteur. House Bill 94. Bringing, is it just? All right, we have people testifying. Vanita Taylor from the Office of the Public Defender. All right, well, there are 4 people who have signed up to testify virtually, including 1, 2, 3, 4 people from the Office of the Public Defender. If you'd like to come on up, you can come on up. We'll include you in the first panel. If we could have those people from the Office of the Public Defender on as well, that'd be fine. Who I'm sure will say things very different from each other and will not in any way repeat each other over and over and over again, and cause me to reflect upon comments that have been made in the newspaper about how we need 2/3 more public defenders. But that's not about you, Delegate Pasteur. Let's hear from you first.
Okay. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of this wonderful Judiciary Committee. You are. And for the record, I am still Delegate Cheryl Pasteur, and I am here to testify in support of House Bill 94, which I did bring before you last session, and you voted favorably on it, and I'm hoping that you will do the same this year. And I can only imagine that there are people here to testify before it, because it is more than a bill that's on our books that is antiquated, and by our own offices, and brought to our attention in 1999 that it was antiquated, outdated, not being used as it had been in its original form. As I pointed out last session, the question is that why is it taking so long to come back? And here we are again in 2024. It is called Correctional Services Inmate Employment Agricultural Work. I call it, as many have called it, the chain gang bill. It found its opening in 1916, and over the many years, it has changed forms through amendments. After 1957, there were no new amendments. And as we sit now, we find that, in fact, in that original form, it does not exist. However, when I came last year, there were 3 states who had reinstituted their own laws for chain gangs or workers, and found, as one sheriff said, it serves as a reminder for people who come down the road that crime does not pay. It serves to make the inmates better people. Since then, one more state has chosen to reinstitute, and it will only take a moment before we in Maryland do the same if we're not careful. It is racially biased, and I ask again for a favorable vote on this. Thank you.
I will move over, but the delegate, in fact, has told me that she's sick.
I'm not trying to catch any germs today visiting you guys. Okay. Okay. Hi, good afternoon. Vanita Taylor from the Public Defender's Office. I'm here in support of cleaning up Maryland's statutes that are antiquated and are racist. The overall population of Maryland's prison system is predominantly African American. I wish that all of the delegates in the room today could close their eyes and envision what it looked like with a chain gang, what it looked like having Black men working fields with overseers on horses with guns. In fact, you don't have to close your eyes because that was recently done at the border where people had guns and they were on horses rounding up illegal immigrants. What we have is something that should have long ago been taken off the books of Maryland. This does not enhance or improve anyone. The only people that benefit from such laws are farmers, owners of farms, or as I would say, modern day prison plantations. Those are the only people that benefit. If anyone has ever seen Ava DuVernay's The 13th, you will understand why this bill is so important. But what is more important is that 7 states have taken out that portion of the 13th Amendment that allows for indentured servitude by the United States. They've taken out of their state constitutions. What we have to be aware of is this, is that if Maryland, we say we're here to reform, we're here to get people ready for life after incarceration, then this is a bill that we would most definitely support. We don't want to be seen as a Southern town where the criminalization of African Americans leads to enforced slavery, even though this bill would say we would pay them what? We believe that this is something that should have been done when all the other bills were done. And I'm here for any questions.
Ms. Green, please, virtually for 2 minutes.
Thank you. Good afternoon, delegates. I'm Terry Collins Green. I'm the Director of the Social Work Division with the Office of the Public Defender, urging a favorable report. I will briefly educate and describe for the General Assembly today what the current exploitation of incarcerated labor in agricultural prison camps looks like in other U.S. states. Last September 2023, men incarcerated at the Louisiana State Penitentiary filed a class action suit, contending they were forced to work in the prison's fields for little or no pay, even when temperatures soar past 100 degrees. They described the conditions as cruel, degrading, and often dangerous. The lawsuit asserts this labor serves no legitimate peniological or institutional purpose. It is purely punitive, designed to break incarcerated men and ensure their submission. In 2022, the ACLU and the University of Chicago Law School Global Human Rights Clinic issued their findings in a research report entitled Captive Labor, Exploitation of Incarcerated Workers. They found that U.S. labor explicitly excludes incarcerated workers from the universally recognized workplace protections. Incarcerated workers are not covered by minimum wage laws or overtime protection. The chief beneficiaries of prison labor are the prison, local, state, and federal governments, and private sectors. In a table in that report listing the top 10 earning correctional industry programs, Maryland was listed as number 9. Maryland prison industries made over $52 million in 2019. These incarcerated workers are paid in pennies. Maryland, the pay scale is 17 cents to $1.16. These men work in dangerous conditions, brutal temperatures, with inadequate water breaks in Louisiana, for example. They work from 7 a.m. to 4 p.m. with little water, working in the fields, and many inmates have reported seeing workers collapse from exhaustion or dehydration while working in the fields on hot days. Those are the things that our incarcerated citizens would face if this bill is not repealed. Thank you.
Thank you very much. Ms. Robinson, for 2 minutes, please.
Thank you. Good afternoon, delegates. I'm Gail Robinson. I'm the Deputy District Public Defender in Baltimore County. When my colleagues had advised me that this correctional article still existed, I had two very visceral reactions. One, that it was still quote unquote on the books, and two, that this isn't the first time that there was an effort to have it repealed. Adjectives like obsolete, antiquated, anachronistic came to my mind. But when I had an opportunity to review the written testimony or the opposition from the Maryland Farm Bureau, then the adjective of alarming came over me. I reviewed the testimony of Delegate Pasteur last year, and I wholeheartedly embrace the sentiment that it is not unreasonable to know that this is something that can be put into practice very easily. If with people that have any authority, there's a current anti-woke movement that is gaining traction in this country. You have high-profile politicians, the former presidential candidate signs into law an anti-woke act. You got the Florida Department of Corrections permeating an education curriculum that really ignores the brutality and the humanity of the American institution of slavery while wanting to purport the personal benefits slaves received as a result of being enslaved in this country. There's a troubling disparity of Black men making up 70% of the population in this country and making up 72% of the correctional popularity. I think in light of the testimony of my colleagues in favor of this repeal and that statistic in light of the opposition of the Maryland Farm Bureau, I believe, and it's my opinion, that it puts to rest that this historical, racial, painful history of slavery puts to rest any myth that painful history does not have an impact on the lives of people of color today.
Thank you
urge
very
a
much.
favorable report of this House bill. Thank you.
Thank you very much. Ms. Desiderio, for 2 minutes.
Good afternoon, all. I'm Elise Desiderio, an appellate attorney with the Office of the Public Defender, urging a favorable report. I am here to briefly share some broader contextual history. In December 1866, after the Civil War and after the 13th Amendment's passage, outside the county courthouse right there in Annapolis, the sheriff put up advertisements for a public auction to lease Black people convicted of theft. Richard Harris was to be sold for 6 months. Gasaway Price and Harriet Purdy 1 year each. The offenses, stealing 6 barrels of corn or a hog or clothes from a lady. The 13th abolished slavery except as punishment for a crime. So instead, convict leasing became a way to get close to the antebellum status quo. State penal authorities rented convicted people to private companies that paid the state, not the incarcerated workers, for their labor. States most often leased out incarcerated Black people. By the late 20s, convict leasing faded. In its place came the chain gang. Incarcerated people, again, mostly Black, were forced to work public works projects, building roads, clearing lands, breaking rocks, outside, often in full view of the public, and chained to each other. White punishment was contained within the walls of the prison. Black punishment was public. By around 1950, use of chain gangs also faded, but not forever, as you've already heard. Nothing is stopping Queen Anne's County or any other county in which similar camps are established from using this law to bring chain gangs back to Maryland. And nothing will until the law is repealed. So we urge a favorable report. Thank you.
Are there questions on this legislation which passed the House 131-4 last year? Very briefly, Delegate Kaufman.
I wanted to just I'm asking, because I wanted to give Delegate Pastor a chance to respond to this. The Farm Bureau believes that these types of camps give returning citizens a leg up for when their time is completed, and it gives returning citizens a leg up in the future. And so I wanted to, I assume you disagree, but I wanted to give you a chance to respond.
Really? Okay. I can't even get out a response.
So
I'm not even.
That sounds good.
I'm
Is
not
there
gonna
another
address
question?
that.
So just very briefly for the record, you disagree with the assertion?
Okay, that's good. I disagree. Okay.
Thank you, Delegate. Will this bill in any way prevent an inmate from going on work release for a farm?
No, this is about working on a for-profit farm or something of that nature and getting paid nothing.
I understand that, but I just want to make sure that in no way this would inadvertently stop an inmate from having work release to work on a farm. That wouldn't affect that in any way.
No.
No, this wouldn't, it wouldn't affect anyone that wanted to, when they're on work release, to work on a farm, if they are from a rural area in Maryland and this is what they wanted to do. No, this would not affect them in any way.
Thank you very much for clarification.
And to pile on, I think it's because the existing language says that the Department of Correction shall arrange for inmates as opposed to if they're looking for their,
Correct.
Okay.
Correct.
Okay. Are there further questions for this panel? Seeing none, thank you all very much. And that mercifully concludes the testimony on House Bill 94. We're going to go now to the Vice Chair. All of my remarks before I'll be better next time. Okay, and yeah, I heard that too. The Vice Chair's bill, House Bill 99. Do you want anybody else? Is there anybody else? Oh, I see even numbers here. Debbie Feinstein, Lisa Jordan, David DeWeese, Joyce King. Jeremy Zacher is informational. Is Jeremy here just so that I know? Okay, that's fine. We'll go these four, then we'll go to you. Okay. The Vice Chair, please.
Thank you, Mr. Chair. Thank you, colleagues. I'm here to introduce House Bill 99. And essentially what we are doing is updating the law to combat current and actual solicitation of minors, which you will hear. Perpetrators know that children are vulnerable when they're online. They can't see them. They can't see the creepiness of the perpetrator. And the offender merely feeds them with lies at their own peril, unfortunately. So I encourage you to read the testimony of some of the witnesses who are not here today, and you'll get some real examples, and I'm sure you'll hear some real examples as well. And from experts who encounter situations and they seek our help to close a loophole. We're going to talk about that. Well, my experts are going to talk about that, that loophole so as to not be repetitive. But the goal is to strengthen the law as it relates to the solicitation of a minor for child pornography. So with that said, Mr. Chair, I ask for a favorable vote from the committee.
Thank you, Mr. Chair. Madam Vice Chair, thank you for introducing this important legislation. Members of the committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 99. You know, anytime we're talking about child pornography, there are two things that I would ask that the committee really keep in mind. And one is, sometimes I think there's this sense of, oh, this is a piece of paper, it's somehow removed, maybe it's not as bad as like physical touching. It is as bad. When I talk to survivors who have had their photographs and films taken as children, it never goes away. It gets circulated worldwide. You have people who were filmed when they were little kids, and now they're applying to college or looking for jobs or dating. And people can see images of them when they were children. This is extremely serious. It is really harmful. It is important that the prosecutors, that law enforcement have the tools they need to really go after the people who are committing this heinous crime. The other thing that often I get asked whenever we're talking about child pornography and exchange of pictures is, oh, what about sexting? So let me tell you the technical side of that. Child pornography is 11207. And so all we're doing in this bill is saying, hey, if you solicit someone to violate 11207, that falls under the don't solicit somebody to violate this law. That same law, 11207, is the heart of what was the chair's sexting law. It says, hey, if you're a kid and you're within 4 years of one another, and this is all like voluntary, that this is not something that's going through criminal prosecution. This is something we are going to treat as sexting in a different way. All that's baked into this bill. For those reasons, we ask for a favorable report on House Bill 99.
Good afternoon. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I chair Intercept, which is the Interagency Child Exploitation and Persons Trafficking Task Force. We service and work with Western Maryland. I'm here in support of HB 99 on behalf of those task force, as well as the Maryland State's Attorneys Association. As my brilliant colleague just really articulated, this is a necessary gap. This is a tool that we need. Just to give you some stats, the FBI estimates that there are between 500 and 750,000 sexual predators online. Now more than ever, there are ballooning numbers regarding online sexual exploitation. The National Center of Missing Exploited Children received 32 million cyber tip reports. And for those of you that are not familiar, cyber tips are generated by internet service providers. And when they identify sexual explicit images or conversations regarding minors. So that's how many times these things are being triggered. What's more alarming is our platforms are moving to end-to-end encryption. Meta just announced that they've moved their platform to end-to-end. NCMEC estimates that there is going to be an 87% decrease in those cyber tips. That doesn't mean that these crimes aren't happening. They're just not going to be reported anymore. So that's the why it's important for this bill, is because we need to support law enforcement to do proactive investigations. This bill, in moving including 11207 in the sexual solicitation of a minor bill, will allow law enforcement to do proactive investigations. I have with me Detective DeWeese, who will talk about some of those UC operations. These are dangerous offenders. I've been before this committee and talked about the progressive grooming nature with regards to child pornography and how they often transition to hands-on offenders and the mass distribution. I really support, and I'm really excited to be before you all and championing this bill, because Maryland has really been on the forefront in fighting child exploitation. So.
Mr. Deweese. Hi, good afternoon, everyone. My name is David DeWeese. I'm a detective with the Frederick Police Department. I've been a police officer for 28 years. Most of that has been doing criminal investigations work. I've investigated everything from murder, rape, robbery. In the last 5 years or so, I've been investigating the online exploitation of children. And I can tell you that it's been an eye-opener to me as to what's out there. I do chat investigations, and I can only tell you what I see when it comes to some of the investigations that I've done. And not only what I've done, is some of my peers have done as well. Just a little bit of a background as far as with these investigations. We're specifically trained to do these investigations, not only as an ICAC or Internet Crimes Against Children investigator, but to do these particular types of investigations. And a great deal of work is that when we do speak with someone online, that person there is directing the conversation. We have a persona that's online of a minor, and that persona is naive, and we're exploitable, and that's the way we want it. We want to be in between us. We want to be in between the chatter, the predator, and the child. When we're seeing the chats that are coming up, we often get contacted for child pornography images. Oftentimes they're very descriptive, and oftentimes they're used as a grooming technique. They're used as a grooming technique because they want to normalize behavior. They want to soften us up, so to speak, and lower our inhibitions so we can then produce images for them. The problem is that once a child produces that image, that predator has them for extortion, sextortion, for money, for sex, for more images.
Okay, we're going to take some questions now. Delegate Carden.
Thank you, Mr. Chair. Thank you all very much for bringing this bill. Thank you, Madam Vice Chair, for bringing this bill. I'm trying to understand what we don't have yet in the code that maybe the gentleman who's the investigator or the state's attorney can help me understand this a little bit better. But it seems like we already have this the crime of committing of sexual solicitation of a minor, and we already have the crime of prohibition against production of and distribution of child pornography. And we're trying to allow for further investigation by bringing them together and being able to charge for both at the same time, because it's
So
not.
there won't be any duplicate charges. So this is a gap. So 11207, the production of child pornography, does include the word solicit, but you have to solicit a minor, a real actual child. So by including 11207 in 3324, that expands the definition to that individual can now be charged if they solicit Detective DeWeese, who is posing as a minor, or in a lot of cases, what I see, which is third-party solicitations, where it's not to the actual minor, but to the minor's parent, their brother, their neighbor, which is not captured in the existing law.
Okay, but and just to be clear, so if you did solicit somebody other than the minor, that is not a criminal offense at all?
That's correct.
Okay. But if you did solicit that other person and then the minor does
produce
something, you can then go after them for that.
Incorrect. So because it's a third-party solicitation on the charge of production of child pornography, that's still not captured. It's only the direct solicitation.
So if you prove that there was child pornography, and the person who helped, even though they were not a minor or not the subject, they facilitated it, you can't charge them.
That's correct.
Great loophole to fix. Thank you.
Thank you.
Further questions? All right, seeing none, thank you all very much.
Thank you.
We'll hear from the informational testimony from Jeremy Zacher now from the Office of Public Defender.
Yes, thank you to the committee. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. I work in our juvenile division. I'm here just for informational purposes only. I think that there are two issues with this particular bill that I would like to bring to everyone's attention. The first is, yes, the duplicative nature of the bill, that the word solicit appears in both the bill because it's a soliciting statute, but the word solicit also appears in the child pornography statute, which is criminal law 11-207. And it seems redundant to have solicit appear in both sides of the statute. And if they're trying to fill a gap with this bill, it seems like it would be necessary to amend both statutes so that solicitation is covered in either a separate statute, completely separate from child pornography, or is incorporated into the child pornography statute, separate from the solicitation. But to have that word solicit appear in both statutes and have solicitation of a minor be covered by both statutes is redundant and could cause someone to be charged twice with the same offense. My other major concern is the issue of sexting. I need to correct one of the last speakers. There is no sexting statute, criminal statute in Maryland. If a child solicits another child to send them a photo, or if a child sends a photo to somebody else, that is charged under child pornography, and in fact has been charged as child pornography in the state of Maryland before. The sexting statute is a mitigating factor. The sexting statute is in the juvenile code. It's Courts and Judicial Proceedings 3-8A-35. It allows sexting to be a mitigating factor when a judge has a child in front of them charged with sexting, charged with child porn, and they can use that factor to decide what disposition that child should have. But it is charged under Maryland as child porn. It is a felony, and it will stay on the child's record forever.
Questions? Delegate Conaway.
Thank you, Mr. Chairman. Thank you for coming in to testify. Could you say the last part again about the forever?
So in Maryland, if a child is found involved or fact sustained with a felony, that offense is not expungible. So it can never be expunged from a police database, for example. So if that child later in life is stopped by the police on a traffic infraction and they sexted when they were 14, that police database may show child pornography as a prior charge. It would only be available to the police. It wouldn't be available to the public, but it stays with the child.
So be shielded from the public.
Yes, juvenile charges are shielded from the public, not law enforcement. And it would be sealed when they turn 21, but it could be unsealed by a court order if necessary.
Thank you very much.
Further questions? Seeing none. Thank you very much for testifying here today. We're going to move on now to, that concludes the testimonies for House Bill 99. We'll go to House Bill 145, Delegate Pippy. And again, Joyce King, Abigail Schaefer. Ms. Jordan, do you want to get up with the first panel or you're favorable with amendment? It's up to you. Okay, and then after this, we have Vanita Taylor and Jeremy Zacher, one unfavorable, the other informational. Did that mean to be both unfavorable? Did it mean to be both informational? Okay, great. We'll take care of that then. Let's go Delegate Pippy, and we'll hear from you.
Thank you, Mr. Chairman. Delegate Pippy here in support of HB 145. This bill deals with both AI and revenge porn. For those of you that don't know, revenge porn is essentially a situation in which somebody has, let's say, some compromising photos of you and they share them in an illegal way. What this bill does is something that we actually did in this committee about 4 or 5 years ago when I served on the committee. I had the honor to serve with many of you here. It addresses when someone creates an indistinguishable image of an individual. So in technological advances, people can now share images that the average person cannot tell the difference between a real image and an artificial image. We address this with child pornography. In this committee, we said that if you shared an image that was indistinguishable from the actual image of child pornography, you would be charged under that section of the code. And so this bill does just that. It states that under the revenge porn article, if you share an image that is indistinguishable of that individual, you will also be held accountable. I think it's the right thing to do, particularly as AI becomes more sophisticated. And again, these images are out there. They're indistinguishable. You cannot tell the difference. The committee got it right 4 years ago with child porn. I hope we can get it right with revenge porn. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 145 with the amendments that are included in our testimony and that I see have also been prepared for the committee. I think that Delegate Pippy really gave a good explanation of this particular bill. These are situations where someone originally voluntarily shared an image of themselves. Often they're in romantic relationships, something goes bad, and then someone takes that image and they share it with the world without their consent. And when the person had a reasonable expectation of privacy, this body has chosen to enact a law making that a criminal act. As originally introduced, there was some concern that the bill was a little overbroad and might have included, cartoons and drawings and art and things like that. So I very much appreciate the amendments which specify that if you've got an image that's indistinguishable from an actual and identifiable human being, then that is something that is covered under the revenge porn law. All of you as politicians are aware of this risk. I know that there has been great concern that public figures will be shown in compromising positions using this sort of alterations. So I'm sure you understand the important issues involved here. For these reasons, the Maryland Coalition Against Sexual Assault asks for a favorable report of House Bill 145 with the sponsor amendments.
Good afternoon, Joyce King on behalf of the Maryland States Attorneys Association. I co-chair with Debbie Feinstein the Special Victims Unit, and we comprise and represent all the jurisdictions here in Maryland and special victims prosecutors. We met regarding this bill, and it was alarming at the amount of deep fake cases that are arising, and we have been unable to prosecute. We do believe that this fills that gap. And I echo the sentiments of Ms. Jordan regarding the amendment. This language has passed constitutional muster with regards to the child pornography statute. So I do believe that these we support these amendments on the bill and believe that this is a necessary change. When we take a look at the intent of the statute for revenge pornography, it absolutely is meant to capture these instances. The perpetual harm, again, talking about these sensitive, intimate images on the internet. And you'll hear from Ms. Schaefer regarding the impact on victims. So we ask for a favorable report on House Bill 145.
Thank you. Yeah, I'm here to illustrate a point. In the summer of 2023, much to my horror, humiliation, and heartbreak, it was brought to my attention that there were images of me online on a popular and widely viewed fetish website. A former friend of mine, Oliver Bateman, had created a page for me on this website where he shared hundreds of images and videos of me. Only here's the thing, it was my face, but the images of my body were not real. Oliver had mastered AI software, which he had used to take real images of me from my Facebook and Instagram pages. And while he kept my real face in the image, he had changed my body and my clothing in the images to make me appear nude and or dressed provocatively and engaging in sexual acts. He had used the deepfake technology to make it appear that I was engaging in pornographic acts in videos. Now, I want to be clear. He was using images of my face from real photos I had posed for, but he had edited these images extensively to make them appear pornographic and engaging in all manner of sex acts. And he was sharing them on a website using my real location, putting me in real danger. This page had 10,000 subscribers. It's very possible that these images could have been viewed by coworkers at the hospital where I work or by anyone. These images looked incredibly real and convincing, but they were not me. The technology has only gotten better since then. Oliver, a pervert with computer skills and way too much time on his hands, could devote untold hours to creating these images of me. But as the AI technology progresses, someone could probably create images like these within minutes if they simply purchase the right app. I took a stand against Oliver. I sought out a restraining order and I filed criminal charges. However, I was told by the courts that what he committed, though clearly criminal in nature, did not actually break any existing laws because the laws had not yet caught up to the technology. Well, we've all witnessed the rise of AI over the last few years. Today, I ask you to criminalize bad actors such as Oliver and update these laws to reflect modern technology and protect innocent people. Thank you.
Any questions? The Vice Chair.
I think my question is for Ms. King. I just don't understand why the language that we had in the statute that says a person may not knowingly distribute a visual representation of another, et cetera, et cetera. Why is it necessary to state the electronic, mechanical, or other means? And why isn't that first part just encompassing, broad enough? I like the bill. I'm just trying to understand why we had to do that.
And I can pull up the specific language regarding, one second. Court's indulgence.
You know what? My colleague might have just answered the question. Is it because, let me just ask it a different way. Is it because it states that person's intimate parts?
That's correct.
Okay.
That's correct.
Thank
I was
you.
looking for the bill. I didn't have it in front of me. That's correct.
Great. Thank you.
Further questions, Delegate Carden?
Thank you, Mr. Chair. And I was actually just going to reflect off of what the Vice Chair asked, but I happen to have been the sponsor of the original revenge porn legislation back in 2013. The question was, I mean, I can tell you that the intent was to make sure that we captured people doing, although the technology wasn't yet there at the time, but to capture this. So has it been tested is really the question. Has the court tried to do it with visual changes and it hasn't worked, or police just afraid, or the state's attorney is just afraid to try to prosecute and not get a conviction?
No, I think in Ms. Schaefer's case, they could not prosecute. The commissioner did not find probable cause.
Okay. All right, good. Thank you.
Further questions? Seeing none. Thank you all very much.
Thank you, Mr. Chair.
Yes. And we'll go now to two people testifying informationally. Vanita Taylor and Jeremy Zacher from the Office of the Public Defender. Come on up.
Good afternoon, Vanita Taylor from the Public Defender's Office. I'm going to give my 2 minutes to Jeremy because we want to be short and brief and not duplicate.
Well, he has 2 minutes, so go right ahead.
Thank you, Jeremy.
That.
Jeremy Zacher, Office of the Public Defender. I was very glad to hear there was an amendment made, although I haven't read it myself. But one of our concerns was the cartoonish nature of some of these AI generated images. I'm going to bring two concerns to everyone's attention. One is the indistinguishable nature that the previous panelists were talking about. If I create an indistinguishable image of Donald Trump on my computer, but he's having intercourse with a dinosaur, is that really an image anyone could take seriously? And so we don't want the statute to capture images that are so ridiculous, even if the image is indistinguishable from the real person, such that they're charged with revenge porn in a manner that I don't think the revenge porn statute was meant to cover. My second concern is the current statute itself says that the statute only applies when the person depicted in the image has a reasonable expectation that the image would remain private. If the image is created on a computer somewhere else where the person depicted had no part in creating it, can that person have a reasonable expectation that the image would remain private? It was never private to begin with. So I bring these things to everyone's attention because I think just tweaking some of the language might improve the outcome. But the way I see this, the current language and this current restriction that the person have a reasonable expectation that the image would remain private would basically undermine the purpose of what this bill is trying to accomplish, computer generated images being incorporated into the statute. That's all.
Questions for this panel? Vice Chair.
Just a quick question. So I don't have an expectation of privacy if I'm walking down the street, right? And if somebody takes a picture of me and does whatever they want to do with it, as far as putting me in some sexual position or doing whatever, I don't understand how your expectation of privacy argument goes where you just went with it. How do you explain if someone is just literally out on the street without that expectation of privacy?
Well, when you're out on the street, you're constantly being taken photos of by cameras, and you could be taken photos of by passersby, and you personally are a public figure. So your image is not something you can have a reasonable expectation of privacy. If someone chooses to modify your image to put you in a precarious position, it is questionable whether or not you have a reasonable expectation of privacy that created image, created by somebody else, authored by somebody else, whether you have any expectation. I think the law is somewhat unclear. When we talk about reasonable expectations of privacy, your privacy in your face is not being violated, and the rest of the picture isn't really you. So I'm just saying that there's a legitimate argument to be made that if someone takes your image and creates a cartoon out of it, creates anything out of it, that new image, you may have no reasonable expectation of privacy.
All right, we'll just, so hold on. Okay, I'm not going to keep going back and forth with you on this one, but I will say that it seems that while there isn't it seems like you're using the expectation of privacy argument to state that while one has an expectation of privacy, one only has that expectation in certain circumstances. But when I'm in another circumstance, if you want, not just me, let's just say anybody, okay? Then that individual's expectation of privacy extends so far or doesn't extend so far. I'm sorry, their lack of an expectation of privacy extends so far that you can just do whatever you want with that. And there are no laws that go around that, when we know, in fact, there are. You can't, I mean, there are boundaries with respect to what an individual can do with someone else's likeness. Would you agree?
Yes, in the civil sense, yes, not in the criminal sense.
Well, even in the criminal sense.
Well, remember, we're extending the visual representation through this bill to describe not images of actual events in which you may have an expectation of privacy, events in the bedroom perhaps, but with fake events that never really happened. And so I'm saying that to cover AI generated images, which is a new field, we're still sort of working our way through it. One may want to re-examine this language about reasonable expectation of privacy in an image was never really taken in the real world, was never taken in your bedroom, and for which you had no part in creating.
Are there any federal laws on this?
I'm not aware of any.
I think so, but thank you. Thank you very much. I appreciate it.
Mr. Chair, can you walk me through your first point again, please?
Which was the identifiable person, the indistinguishable person. So I heard the previous speakers speak about this bill only covering when a person's image is indistinguishable from the real thing, which I would agree if the person's indistinguishable from the real thing and engaged in that kind of activity, yes, it would cover it. But if the image itself is, as I mentioned, Donald Trump having intercourse with a dinosaur, if the viewer or reader couldn't possibly think this was a true image, is that still something the revenge porn statute is meant to cover? And if not, then merely saying the person being indistinguishable may not be sufficient to accomplish what we're seeing. We may end up bringing more people into the statute than we intend. So I think one thing that may want to be looked at is not only the indistinguishable nature of the person depicted, but whether or not the picture can be reasonably perceived to be true. Someone could be fooled by it. That's what seems to happen with one of the previous speakers.
So if I were to take some sort of source image and create a modified version via Photoshop or whatever, but it was a real image, could I be prosecuted for that currently?
Currently, if it was a computer generated picture?
A real image that I had modified.
Well, I think that's I think it's unclear. I think that was the purpose of expanding the definition of visual representation to include computer. I assuming you're talking about you modified it through a computer.
Well, most of these laws, the way they apply, the way I read currently, it's that if you can't just take a couple degrees of separation and all of a sudden you take a real image, you modify it a little bit, and now you're not prosecutable. That's not my understanding of the way it goes. And when you talk about AI, I mean, a lot of these programs, you could take a real image of a person, you could plop the link right in a generator and say, on a dinosaur.
Mm-hmm.
And it's ridiculous, but it's still the source image. You know what I mean? It's just, to me, it's one more degree of separation. And I don't know, you know what I mean? It's a hop, skip, and a jump away from plopping a real image in Photoshop and putting a filter on it. And it's still being a real image.
Well, I understand that this statute also requires sexual activity. If I took just a nude image of someone, it would not be covered by the revenge porn.
Right.
So you're really talking about integrating a real image with a computer generated image. And then the question becomes, could someone be fooled by that? And even if they couldn't, is that something we want to include in the revenge porn statute?
Okay, thank you.
Seeing no further questions, thank you very much. Appreciate it. That concludes the testimony for House Bill 145 and brings us to our last bill of the day for House Bill number 70 with Delegate Hill, who's right there. And do you have anybody else?
Good afternoon, Mr. Chairman. Good afternoon,
Kevin
Madam.
Kennelly from Mako? No, all right, go right ahead.
All right, Vice Chair and members of the committee. Interesting afternoon to hear the last couple of bill hearings. Obviously, you all are really aware of how we have to continually keep up with technology to make sure that we ensure the safety of residents of Maryland. So really simply, House Bill 70 is a bill that this committee passed unanimously and that the House passed unanimously last year. And we did that because it does something really important. It is the product of the Next Gen 911 Commission's recommendations. And it is also the product of the work group that looked at public safety and public safety interference. And it was co-sponsored by the Vice Chair and Delegate Munoz and Delegate Lopez, who worked on in that work group. And essentially, it expands on existing penalties that we have for abuse and misuse of electronics in order to cause disruptions in our system. Specifically, what this bill does is create significant penalties for people who deliberately disrupt 911 answering centers. For people who use electronic or other means to disrupt those systems and fail to disrupt them, there is a penalty of 5 years or $25,000 max. For people who actually succeed in disrupting them, and what that would mean is you call 911, but you can't get through because a robo mechanism or something has taken that system offline. So you can't get the emergency services you need because the PSAP has been taken down by malicious actors. In those cases where they've actually been successful, the fine would be 10 years or $50,000 max. That's the bill simply. And any questions?
Any questions? Seeing none. All right. That concludes the testimony on House Bill 70, and that concludes the testimony today for the House Judiciary Committee. Only 2 hours. I don't know what we'll do with ourselves. Thank you all very much. We will be back here tomorrow at 1 o'clock. Thank you.